how actors outside a country can effectively advance domestic efforts to address a wholesale breakdown in protection of human rights. When these issues first claimed concerted global attention in the late 1980s and early 1990s, a key question that we debated within the human rights community was whether international law and external actors in fact had anything useful to contribute to societies that were emerging from extended periods of brutal governance as they came to terms with their recent past. At that time, we could hardly have imagined the legal landscape that would soon emerge, in which international criminal courts sometimes provide a backstop for failures of justice by national courts, and sometimes catalyze action by them, in which international and domestic judges sit side by side in the hybrid courts, and in which foreign prosecutors are embedded in national judiciaries along the lines of what Claudia Paz just described in Guatemala. In this setting, a key challenge today is to capture lessons from a growing set of wide-ranging experiences of global engagement in efforts to redress atrocities so that we can do better in the future. And that's the central theme of this panel. Our panelists bring to this discussion very rich expertise and insights into a range of different models of external engagement into domestic accountability efforts. Judge Patricia Whalen served as an international judge in the War Crimes Chamber of Bosnia State Court from 2007 to 2012, which was the last year in which international judges served on the chamber. But the Bosnians with whom she served didn't want to let her go, and they persuaded her to serve for 2 more years as a special advisor to the state court, focusing on judicial education in international law, judicial management systems, trial management, designing judicial education programs, practicing in hybrid legal systems, and portfolio. I'm going to stop here and give you time to talk about that. Sandra Orlović is Executive Director of the Humanitarian Law Center, really the preeminent non-governmental organization in Serbia, and has played a leading and very critical role in ensuring not only that Serbia cooperate with the Yugoslavian Workers' Tribunal, but more important, ensuring that its domestic war crimes chamber and prosecutor, which Sandra will talk about, work as effectively as possible in an extremely challenging political environment. Zoon manages a project for the Open Society Justice Initiative in Mexico, which assists civil society in bringing strong national level legal claims for accountability and disappearances, torture and killings, and other serious abuses, and provides technical expertise to national prosecutors and investigators genuinely committed to resolving great crimes. Finally, Rivera, who's a constitutional law specialist in Colombia, is senior researcher for the International Center for Transitional Justice. In that capacity, he's analyzing legal frameworks related to the prosecution of international crimes and monitoring the legal and practical developments of the justice and peace judicial process in Colombia, about which we'll hear shortly. I'm going to ask each panelist first to begin by briefly describing for us the key forms of external engagement in the accountability processes with which they've been involved, and if relevant at this point, maybe offering a few reflections on key aspects of how that engagement was structured, and again, if relevant, lessons learned about how that external engagement either worked well or might have productively been restructured. And then I'm going to ask a broader question about lessons learned from their experience. So perhaps I could turn to Judge Whalen first. Thank you.
Thank you very much. I appreciate being given an opportunity to speak about the State Court of Bosnia and Herzegovina. And for those of you who are privileged enough to hear the prosecutor this morning from Bihać, Yasmin Mekic, I think I'm not going to go over again the reasons for the court or the history of the court. Only to say that the impetus for the court began in 2003 and the court became functional in 2005. In that 2-year period, it was a period of tremendous activity, and it was fueled by the international community, specifically the Office of High Representative in Bosnia and Herzegovina at the time, the ICTY, and the donor community of the diplomatic staff that was present in Bosnia and Herzegovina at the time. But often overlooked, and I think a real mistake in overlooking this period of time, was the amount of work that nationals put into the court. Nationals were at the table right from the beginning in creating the new statutes, the 2003 code, as well as the new criminal procedure code. They were involved in the bricks and mortars of building and building. The registrar and staff of the court were primarily all nationals, as was the entire state court of Bosnia and Herzegovina. The international community presence at that court was very important, I think, to the operation of the court, but we can't forget that it was staffed by 80% of the nationals in the country, and great credit has to be given to them. And the only reason why I mention this right now is that early on, this was a mistake, because I believe the people of Bosnia and Herzegovina see the court as a function of the international community, as opposed to a court that belongs to them. And I think this is a real problem, because after the international staff left, the national court was more or less left alone, and it became the fact that it had been started by the international community, in quotes, it became a weapon that was used against them. And I am afraid that maybe eventually this might hurt the court more than we can presently imagine today. In addition, I would like to just point out that I think right from the beginning it was clear that, like the ICTY, that had limited jurisdiction to try the most culpable, the state court also was not going to be able to try everybody either. We were referred to as the court that tried everybody else, and in fact we did try everyone from generals to foot soldiers. But it was also clear that the underlying structure of the legal system in Bosnia and Herzegovina also had to be developed at the same time. And I think we're a little late in the game on this. We should have been working very early on with the entity courts to develop their expertise and capacity to hear these cases. I think the only other point I want to make about this is that while the international staff, and particularly I can speak for the judiciary, while the international staff was very important, there was just an arbitrary timeline given to us about when we were going to leave. And that was very dangerous. It was not based on any specific goals. There were no clear markers about when would be a good time for the international staff to leave, but it was really a political decision. And because of this, we didn't even realize our value to the national court until after we were gone. And one of the most important lessons was that we served as a firewall between for the national jurists that were sitting on the court. The war didn't end with the Dayton Peace Accords in Bosnia and Herzegovina, and it's still being fought today. It's being fought in the parliament, in all the government institutions. It's being fought between the entities. All of the reasons that created the conflict are still alive and well today in Bosnia and Herzegovina. And when we left, we created a vulnerability for the national jurists that impacted on their ability to be a true and independent judiciary, which I think is the goal of international involvement.
follow-up question. I'm intrigued by your first point. I'm intrigued by all of them, but your first point about how this is seen as a product of the international community and how that's created a vulnerability. I wonder, in retrospect, how could the international community have avoided that impression in the way it constructed this?
Well, I think they took a lot of credit for creating the court. I mean, part of it was to continually acknowledge their national colleagues and put their national colleagues in front. I mean, you know, who are we to come into a country and tell the people how to do their judicial system? But the truth is that we have a lot to offer, but they have a lot to offer as well. And I do believe the movement for creating a new judicial system, and it was dramatic what took place in Bosnia and Herzegovina. It had been a civil code, and then in 2003, the code became a hybrid code with many elements of common law. This is a huge sea change, and for the legal community to make this transition, they had to be seen to be leading that transition and lead to that transition. And I think, unfortunately, for many of the practitioners, I mean, you can imagine if you're a common law trained lawyer and all of a sudden you're thrown into a civil law system and you have to perform in the same way you perform in the system that you're comfortable with. It's dramatic. It's very difficult. And they were being there's a perception by many legal practitioners in Bosnia and Herzegovina that this was forced on them. And so their need or their willingness to change, there's a reluctance there. But that isn't the truth. The truth is that many nationals believed that their system needed to be more transparent, it needed to be transformed, and the system that they had in the former Yugoslavia was not sufficient to sustain the kind of trials that they were facing for these crimes. So the motivation was very strong at the time, but it just wasn't publicized enough, talked enough, and within their own legal community. I think the internationals, to be honest, why do we need to take credit for some of this work? I never understood that. And, you know, all you ever heard about was the OHR, the IC2R, the OHR, the IC, you know, blah, 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 blah. And I don't want to take anything away from that institutions, but there were a lot of people at the table that never got recognized. And the failure to recognize them, I think it has come back to haunt everybody today.
I want to stay in the region, and I'm going to turn to Sandra Orlović first. Again, same question. Can you describe who the key external actors were and how they got involved?
Before I answer to your question, I want to make just a few short factual remarks, just in order to make clear what are the specific challenges of the situation in Serbia. Same as other countries in the region of former Yugoslavia, Serbia has specialized institutions for war crimes prosecution, which were established in 2003 after the ICTY announced its completion strategy. And what is most important for today's discussion is that Serbia has the biggest backlog of the cases, maybe the same number as Bosnia and Herzegovina. Probably some of you may know that many of perpetrators from the region, from Bosnia, Croatia, and Kosovo, found the I would say safe haven in Serbia after the war by taking the citizenship of Serbia. So many of the perpetrators of war crimes in former Yugoslavia are now in Serbia, and our domestic institutions have this huge challenge to prosecute at least the biggest number of them. From the very beginning of the war crimes prosecution in Serbia, there were a wide range of international actors engaged in Serbia. Of course, the most important one is the International Criminal Tribunal for former Yugoslavia. I will speak a little bit after when we come to the issue of positive and negative lessons learned. But also, I would highlight this OSCE and European Union. Probably all of you know that the whole region, all countries in the region of former Yugoslavia are candidates for membership in European Union. So European Union is in a way the most important international interlocutor for all our countries. So the process of the integration into the European Union offers a very important opportunity for societal reforms, which also include the domestic war crimes. And also, there are a lot of other individual political actors, individual countries who deploy a lot of development aid in Serbia, and of course, universities and academia actors as well. I will stop here.
I have a shift to Mexico. Can you describe the context in which external actors become engaged in the process or involved in Mexico?
In the Mexico situation, one cannot praise enough the intervention of the United But today, we want to focus on mechanism of new mechanism that is organized via International Commission of Human Rights. International Criminal Court is not yet involved in Mexico, although received communications from Mexico. There is no involvement of the International Criminal Court in Mexico. So today it's about a very specific mechanism that is still ongoing, and the recent and the transcendental mechanism organized between the Inter-American Court, the Mexican government, and the families and the representatives of disappeared persons in the state of Guerrero. And to start with, I will take 1 minute maybe to talk about the situation of violence and impunity in Mexico and Guerrero, and a little bit about the case that triggered the existence of this mechanism. So, first about the situation, everybody knows probably, how violent became Mexico in the last 10 years. But I would like to provide you some data from research that just finished is going to publish very soon on the levels of systematic impunity. So, on homicides, intentional homicides in Mexico, last 10 years rise to 160,000 intentional homicides. And in the state of Guerrero, that is the state, the most important state in the mechanism, intervention mechanism, the prosecutor office received 19,000 complaints or reports on intentional homicide. That means 5 reports of intentional homicides every day, 365 days per year for the last 10 years in the world. Out of that, 14 out of 15 homicides remain unpunished in this state. At national level, in the Calderon era, that it means 2007-2012, 4 out of 5 intentional homicides went unpunished. Considering part of the Peña Nieto administration, that is mid-term right now, in the period 2009-2015, prosecutors issued indictments only for 16% of intentional homicides. On disappearances, on the official records are 25,000 persons registered like right now, and Mexico is notorious unreliability and incompleteness of the data they provide. On accountability, it's zero. On disappearances, in military, one soldier was sentenced for enforced disappearances last year, 2 months ago, and 6 policemen were in the line in the last 10 years. On torture, the National Human Rights Commission received 9,217 complaints of torture. 1 out of 5 were investigated, 12 indictments, and 5 convictions. So, this level of violence is attributed to the militarization strategy of the President Calderon, and which is continued by the President in the context of the war on drugs. The government claims that the majority of these crimes are committed by organized crimes against right groups, and the NGOs maintain that there is a significant percentage of them are committed by state actors or state actors in collusion with organized groups. Now, that is a systemic impunity in Mexico. What triggered the international intervention was something that probably you all heard about, the disappearance of 43 students from a rural school in Ayotzinapa in the state of Guerrero. And the fact of the case were that one night in September 2014, 6 people were killed and then 43 students disappeared, being attacked by the municipal police in what it was called an intent to stop a protest. Right? The federal investigation started 10 days after the fact. The families immediately requested precautionary measures from the Inter-American Commission, the Inter-American Commission, and immediately after, the representatives of the families asked for monitoring of the implementation of this precautionary measure to protect the students that in that moment they were missing. Mexico was in an uproar. At that moment, the international press was covering the events. The government was under tremendous pressure to provide a political response. So the family suggested, and the government immediately agreed, to request technical assistance from the Inter-American Commission for the investigation and prosecution of it. So immediately after, an agreement was signed to form a group of experts, interdisciplinary group of independent experts, to come to Mexico and to help the General Prosecutor Office with the investigation. Immediately after that, in January, so 3 months later, the General Prosecutor of the country called for a public press conference, and declared that after a very serious and deep investigation at the local level, it was the historical truth was established. This is how the prosecutor called the findings of his the historical. And the official version was that the students were attacked by the municipal police in an intent to stop a protest, and they were handed over to a local drug cartel who killed them and burned them in a garbage dump next to Iguala, the capital of Guerrero. All of them, and there were no DNA, sufficient DNA at the place to identify the bodies. now, that was the official version presented in January 2015, 2 months before the international group start to help the prosecution to investigate. The families refused to accept that version, and international organization echoed that, and this was the context in which the group of experts started to work. The group of experts is still working, presented a preliminary report last year in September, and it is supposed to present the final report.
Thank you so much. And finally, Henry, you have a very complex context to describe, but if you could get us started by describing the context in Colombia in which you are working, external actors have been, had a nice foundation for later remarks.
Bueno, gracias. Yo creo que en primer lugar tendría que mencionar cualquier consideración que se va a plantear por el caso de Colombia, América, que se tengan en cuenta dos aspectos fundamentales. El primero tiene que ver con la necesidad de buscar una salida inicial al conflicto, esa tensión enorme que existe en el país por sacar adelante un modelo de rendición de cuentas que efectivamente respete los estándares internacionales, a tiempo resuelva la demanda de justicia de las víctimas, pero pues digamos que también sea compatible con el planteamiento de buscar una salida negociada al conflicto armado. Un conflicto armado que además tiene múltiples actores, durante más de 50 años. Entonces, ya estamos. Decía que el aspecto primordial en toda esta discusión es cómo buscamos, cómo preparamos un modelo de rendición de cuentas que facilite un modelo de cuentas que incluye a todos los actores que han participado en la rendición de las cuentas en Colombia. El tiempo satisfaga las estándares internacionales. Sobre esto, digamos que en este instante en Colombia tendríamos que tomar en cuenta que producto de las negociaciones que se adelantan en la banda, las partes del gobierno de las partes anunciaron en diciembre del año pasado el acuerdo, uno de los acuerdos más esperados de esta negociación, que es relacionado con la creación de un sistema integral de verdad, justicia, reparación y garantía de los derechos. Este complejo sistema está conformado por las partes que han manifestado en parte, está conformado por una comisión para el esclarecimiento de la verdad y la convivencia, la unidad especial para la búsqueda de personas dadas o desaparecidas en el conflicto, la jurisdicción especial para la paz y la ampliación de medidas de reparación integral para la construcción de la paz. Todos estos mecanismos son fundamentales para comprender y para, digamos, avanzar en la lógica de las respuestas en términos de justicia, no solo en el ámbito de la justicia penal, sino también desde otro tipo de medidas de justicia o justicia orientada a resolver la demanda. Yo diría que ese acuerdo que tenemos hoy en Colombia es posible, o fue posible construirlo a partir de dos factores. Primero, tiene que ver con las lecciones aprendidas con respecto al país. Después de 50 años de violencia y de varios intentos de lograr una salida negociada en la historia con los conflictos de Colombia, se han aprendido muchas lecciones. Y por otra parte también el trabajo que han realizado organismos internacionales, corredores internacionales, instancias internacionales que han orientado un poco esta discusión. El modelo que hoy han acordado las partes, digamos, en principio, es un modelo orientado a garantizar que no exista impunidad por las violaciones a los humanos. Así lo presentan las partes, así lo presenta el gobierno, así lo presentan las partes. Sin embargo, pues digamos, hay una amplia discusión sobre el alcance de ese acuerdo, porque define algunas categorías que no son claras en el derecho internacional. Sin embargo, decía que los crímenes internacionales no podrán ser objeto de amnistías o indultos. Y al tiempo también establece un catálogo de delitos orientados como las crímenes internacionales que tendrán que ser llevados a una instancia judicial. Por ahora yo solo diría que en Colombia podríamos hablar de tres momentos esenciales. El primero son los procesos llevados a cabo antes de los 90, y esto lo digo porque la Constitución de Colombia en 1991 que elevó de alguna manera los estándares de lo que tenía que ser el trabajo de la justicia penal. En esos procesos anteriores a los 90 lo que veíamos era un esfuerzo por desmovilizar a los grupos armados y de pronto lograr medidas para la preservación del orden público, pero no propiamente se incluían en este movimiento el respeto a los derechos de las víctimas. Tal vez fue el segundo momento, tal vez fue con la entrada en vigencia de la ley de justicia y paz, que en Colombia se empieza a hablar de la necesidad de dotar de un esquema mucho más ambicioso el ejercicio de rendición de cuentas y el ejercicio de garantía de los derechos de las víctimas. Esta ley de justicia y paz básicamente fue el marco jurídico por medio del cual se desmovilizaron los grupos paramilitares en el año 2005. Lo que en principio se había propuesto con esta ley era un modelo de alternatividad penal que renunciaba a la restricción penal de un gran número de conductas y por otro lado consideraba penas y sanciones que en ningún caso digamos, consideraban las medidas de verdad como sanciones laborales o privaciones de libertad. Ampliamente esta ley fue criticada por sectores sociales y sobre todo también por la comunidad internacional que además le recordó al país y le recordó al gobierno de la época que ya se normaba el Estatuto de Roma y un modelo de esa naturaleza no era sostenible por los estándares internacionales y una serie de actores internacionales clave para construir o más bien para llenar el contenido de esa ley de justicia y paz. Por un lado, la Comisión Interamericana de Derechos Humanos había entregado unos informes y conocimientos relacionados con las situaciones de impunidad que vivía en Colombia. Atiende también una corte interamericana había producido ya un par de sentencias en donde demostraba cómo en Colombia no se habían abordado las investigaciones de violaciones a derechos humanos de manera transversal. Pero sin duda también un gran digamos, actor de toda esta cuestión es la Corte Interamericana, la Fiscalía de la Corte Penal Internacional, que decide pues, digamos, mantener a Colombia en una observación preliminar y produce informes. El primer informe muestra al país la situación de la impunidad en crímenes de competencia de la Corte, pues, digamos, era toda la situación recomendaciones, sin embargo, a partir de esa alerta de la Fiscalía en Colombia empiezan a generarse en el sistema interno. La Fiscalía avanza en la noción de la necesidad de preocuparse realmente de los crímenes de competencia de la Corte y las organizaciones internacionales empiezan a transformar los términos de las exigencias de la Fiscalía de las Respuestas. Yo empezaría en este punto con la situación actual que estamos viviendo en Colombia y precisamente por el acuerdo del que se hablaba las partes del final quieren que el movimiento considera un proceso de paz sin tomar en cuenta los derechos de las víctimas no positivos. De esa manera se orientaron las discusiones sobre cuál era el modelo de rendición de cuentas más adecuado, tomando en cuenta además que ninguna de las partes confiaba por una confianza sobre el sistema de justicia interna. Los países tienen sus cortes, un sistema de fiscalía general bastante robusto, un tratamiento jurídico internacional y la opción que tomaron plantear un tribunal especial, un tribunal nacional, pero con presencia de jueces internacionales. Esto es muy interesante, es un trabajo internacionales, no solamente porque existen jueces internacionales, sino la nueva comisión que se cree necesitará apropiarse de estos discursos en la lógica de cumplimiento de los estándares, pero también tendrá que buscar un paralelo, un equilibrio con la realidad jurídica interna. La creación de esta figura de la Comisión Especial para la Paz no está orientada propiamente a establecer el sistema de justicia, sino al contrario, confianza a las partes de la misma sociedad sobre la posibilidad de que en el mismo país se logre tomar
Some of you have already touched on some of the lessons learned from the external engagement that you described in the foundation for, but I'd like to turn first back to you, Judge Whalen, elaborate somewhat on some of the other lessons learned. Maybe with a view to talking about how things might have been done a little bit differently, again, as you haven't already named in Bosnia, to improve on the justice line, but also with some of the successes involved.
Well, I think understanding that the task to create an independent judiciary is really huge. And I think most of the international actors, underestimated really how big that is to create true independence. But one of the things that I would like to start with is just talk about the selection of judges. And I'm speaking particularly about international judges. I think these judges have to be able to not just come with the expectation that they're going to sit on trials, but that they're actually going to create and build an institution. And this is a lot more work than just sitting on a trial. And it's extremely important that we have dedicated international judges that understand that this is the task. And that everything you do there is important. Speaking what Henry just mentioned is this issue of international standards versus domestic standards. And I like to think of that issue as our international standards so different from domestic standards. I'm not so sure they are. What you have is you have domestic traditions that are different. And you have to look at those traditions figure out what works and what really needs to be revised or looked at. And I think the trick in working with domestic colleagues is to look at where we intersect, where our legal values are the same, and how do we get there within the context of the domestic structure. One of the things we did that was very successful was creating a judicial college. And this was an opportunity for national judges as well as international judges to create collegiality, to talk about problems, how to solve problems. There was peer-to-peer, and we created a lot of judicial education that was based on how to do something. They get a lot of theory, and a lot of academics come and teach about international law. But the basics of like how you actually do something, many of these judges need that type of foundation. And that's really no different than American judicial education. You know, how to do an arraignment. You know, okay, many people think that's pretty easy and they know all the basics. But I can tell you that many judges have to be taught how to do that. They only need it once, they don't need it 100 times, but they do need to be shown how to do that. So it's that type of education that I think is really helpful. You know, how do you actually do something in the courtroom? How do you manage trials when you've never actually done a trial before? There's certain skills to managing trials, and those things need to be taught and can be taught. In addition to, and I think one thing which was very good was the initial infrastructure of the court. Just in terms of the state court has wonderful facilities. There's facilities designed for witness protection, for video link testimony, for actually making court of record, AV recordings, equipment for security and interpretive services. But there also needs to be an understanding that the financial commitment to bricks and mortars continues on, and that has to be a sustainable commitment by the donor community. I believe another thing that did not work well in Bosnia and Herzegovina was our public information services. And this was, in my opinion, was a huge mistake. There needs to be extensive public education on the courts, on the legal system, what courts do, how they work. It has to be in the schools from first grade on. There has to be a community and public discussion about these issues. And we also need to have good websites, easy access to research. I strongly, you know, it's funny, in the United States, I'm not really fond of court TV, but I really think in Bosnia and Herzegovina, court TV would have changed the landscape. The courts are open, but the notion of transparency and the fact that you're a member of the public and you can just go into court, it is not known there, it's not accepted. The court is still seen as more of a private function. And I think court TV, the actual putting on the trials, making them accessible to the people in the country, one, they would have learned a lot about the war. Many people were ignorant about the war. They knew what happened in their community or in their town, but not overall. This just would have made a huge difference. And I think, for example, I just want to speak a little bit this on the transparency issue. The Court of Bosnia and Herzegovina was mandated to have a public information office. And the people that staffed there, while they were very good, the only educational requirement was high school education. They were not really skilled in this particular area of public relations and getting the word out. If you read today, if you go to the court website and you want to find out what happened on the verdict, I defy anybody to know or understand what actually took place in that trial. And it created a lot of conflict with victim communities because often, especially in the area of an acquittal or a reduced charge, because often the crime was proved. There was an acknowledgement that yes, this crime did indeed happen, and that was extremely important to get out.
But then they needed to explain why this particular person was not found guilty of that crime, and that could have been because of evidence linking that person to the event. But that is never explained. So people start having a very poor opinion of the court. And the other thing I would just want to say for anybody who's thinking about being involved in any of these situations, I think the thing that worked best for ourselves as internationals was creating an environment where we talk law. In Bosnia and Herzegovina, it's not traditional for legal officers to just sit around and talk law. You know, what about this? What about that? What do you think about this? And part of that is just because of their legal training and how their legal law schools were structured. But it was really exciting for me to, you know, I had an open door office, you know, anybody could come in. I had legal officers continually coming in and judges coming in, asking me questions. I was not an academic in this area. I didn't necessarily know the answer. I said, let's find out together. You know, let's find out the answer to that question. Let's read articles, journal articles. Let's look at what the academics are saying. Let's look at cases. How have other courts decided this issue? And for me, that's sort of the stuff of being a judge, but for them, it was new territory. I just went back in October, and I got a phone call from one of the legal officers, and she said, oh, can you come and have a coffee, and can we just talk law? And she said, that's what I miss when you're gone. I just miss those conversations. And we have to, you know, talking law is planting seeds. You can't do everything at once, but you can create seeds of change. And you can live by example. And I just want to talk a little bit, I know I'm maybe taking too long here, but what's really important is to understand that you can impact domestic systems, even if the standard that you're trying to put forth is not contained in that domestic system. And an example of this is the pretrial procedures in Bosnia and Herzegovina are much more based on civil law than common law. So for an example, the prosecution can turn over vast amount of evidence to the court, but not to the defense. So in these early pretrial hearings, where custody is the issue, the court may be the recipient of a volume of evidence that the defense counsel does not have. And the statute allows this, it's perfectly permissible under the law, because it's perceived as an investigative state. But when I was there, I just said, well, I'm not gonna do that. I'm only gonna base my decision on the evidence that the defense has. And people were really shocked. I mean, they were like, well, you know, you can't really do that. And I just said, well, I can't really not do that. And this was important for them to understand that there was an inherent right here, a fair trial principle and equality of arms. And making that point was difficult, but important. And over time, the statute didn't change, the law is still there, but now the tradition has changed. And custody is now routinely being decided on just the evidence that is there by the prosecution and the defense. And enough said.
I have a lot of questions. I'd love to ask some follow-up. I'm going to save it until later. I just want to ask you to narrow down to say something that is implicit in what you said before, that we talked about before, which is how would you define the purposes of the international justice? What were the goals that were meant to be achieved? Because to some extent, I think you suggested maybe your understanding of what you could contribute evolved as you actually spent time on the court.
I mean, I think the goal should be to create an independent judiciary. A judiciary that is professional and competent, and makes decisions based on the evidence put in front of them, and they can explain their decisions through legal analysis. And those seem to be fairly simple and straightforward goals, but in fact, it's very difficult to actually do. But every single thing you do should be with that goal in mind. You know, you're there to work, number one. And not a lot of international judges had that goal, I could say. And that was shocking to me, actually. It was sad for me to see judges who just wanted to come and show you sorry, which is wonderful, but not quite prepared.
Well, I outlined three positive lessons learned and three negative, although there are many of them. First, of course, it's obvious the financial and expertise support to the domestic institutions, not only in Serbia, but across the region. Not only in the technical sense, in giving money for strengthening technical capacity, but also enabling representatives of domestic institutions to travel to get training from the ICTY staff, from the staff of other international and hybrid tribunals. As you probably know, our domestic staff didn't have any experience in prosecuting crimes against international humanitarian law, so this was a fundamental issue at the early stages of the domestic war crimes prosecution. Second, very important model of engagement was the facilitation of the regional cooperation of domestic prosecutor office in the region of former Yugoslavia. OSCE was facilitating this process, and it ended in the several bilateral agreements between domestic prosecutions in the region, effectively enabled a fast exchange of evidence and information among prosecutors' offices, which basically replaced and overcame the long procedures of the legal assistance among the states. These procedures can take sometimes longer than 1 year. So what these regional cooperation and these bilateral agreements enable is that, for example, Bosnian prosecutor and Serbian prosecutor can exchange information directly, not through the Ministry of Justice. And third positive outcome of international engagement is related to the ICTY, and I see it as one of the most important, most valuable assets of the work of the ICTY, and that is the archive that ICTY created. ICTY created something like it as I would call it mirror archive to state archives in the region. And this archive today is used by domestic prosecutors and also by the public. Public has access to the public part of the ICTY archive, but nevertheless, it's a very important asset from the work of the ICTY. And this becomes more important when you see today that, for example, in Serbia, domestic, our national war crimes prosecutor has enormous problems in accessing archives of the police and military now, because Ministry of Interior or Ministry of Defense are enabling them to access their archives, saying that they don't have some particular documents or they were burned in the dangerous environment. So this is really important. Of course, I need to remind you all that ICTY archive was created in a way to UN and other international actors obliged the states in the region to transfer parts of its archives, not to the whole, and that is the problem. Some cases in the ICTY dealt only with some particular events, not the whole. I will go now to negative.
Just a model of transferring, developed over time among some of the ways ways that both prosecutors have access are, David Colbert is here, and he's involved in developing this when he was at the ICTY, access from Serbia to an electronic database of the ICTY. Training programs where local workers, prosecutors from Serbia and other countries in the region actually go to the ICTY and spend 6-month rotations there, facilitating further access of their colleagues back home to the ICTY. Maybe something else I'm missing, but really significant concrete programs.
Yeah, that's the main mechanism through which domestic prosecutor office has access to the ICTY archive. Besides that, they have online access from Belgrade office to the OTP archive, non-public part of the ICTY archive, and these are the main two mechanisms. Although they are now complaining that the procedures are too long, that the protective measures set by ICTY cannot be cancelled, that there are many challenges in this matter. Yeah, and going to the negative lessons or lessons that should be learned from the example of former Yugoslavia and the Serbian example, I think that the international community, and I will now mainly refer to European Union as I said, main interlocutor for international interlocutor for Serbia. I think that there were no enough attention to what I call auxiliary issues, such as vetting procedures or access to archives for domestic institutions, or witness protection program, or reform of police units who are involved in the investigation of war crimes or witness protection programs. For example, lack of vetting procedures is so obviously contributing to the impunity in Serbia, because at this moment we have a number of individuals holding high positions in government, in the police, in the military, who are clearly obstructing the investigation of war crimes. Just last summer, we learned that Minister of Defense declared the one part of the archive of the Serbian military as a state secret, the highest level of secrecy that one document can get in Serbia. After my organization started investigation of the documents in relation to this year. So it was obvious that the Minister of Defense wanted to protect the military federal second negative lesson that I want to outline is that, of course, there was no continuous financial and technical support to our domestic institution. This extensive support lasted for 4, 5, 6 years in Serbia until since 2003, and everything started decreasing in 2007 and 2008. For example, all judges in the trial chambers were changed after 2007, 2008, and they received no training on international humanitarian law or interrogation skills, etc. Also, Office of the War Crimes Prosecutor in Serbia is now relying only on the state budget of the government of Serbia in terms of resources and financial resources. And the very illustrative fact is that, for example, our Serbian prosecutor, 2 prosecutors are sharing one ambulance. So how can you expect from them to deal with such complex cases, for example, Srebrenica and some mass execution cases in Bosnia? And the last point I wanted to make is in relation to a broader political issue. And I think that there was through these years and the work of the domestic institutions, we could see that there is an inconsistent or uneven political So what I wanted to say is that since 2003 until this very day, domestic prosecution is working in parallel with the ICTY. But what we have seen is that until 2012, international community and mainly European Union did not actually pay attention to what was happening inside Serbia in the domestic courts. For the first time, only in 2013, the European Union mentioned the problem of not indicting high-level officials. So can you imagine that from 2003 and 2013 was a decade until the European Union noticed that something is not going right in the domestic prosecutions. I wanted maybe to conclude this by saying that I think that the international community and especially European Union is functioning all these years on one false assumption, and that is that institutions in Serbia and of course in the whole region are transformed in such an extent that they are capable and they have generally built to confront the legacy of the past, which is of course not true. And of course I will end with just one illustrative situation which depicts this willingness of the Serbian institutions to confront with the legacy of the crimes in the 90s. In December of 2015, the Ministry of Justice prepared the draft of the National Strategy for War Crimes Prosecution, of course, on the basis of the strong incentives coming from the European Union, and they published that draft, and just a couple of days after that, our Minister of Justice, whose ministry prepared this draft strategy, organized official welcome reception of one of the military generals who was convicted by the ICTY. So this was the state reception, the state welcoming for the convicted war criminal, and our Minister of Justice said he is a role model for the next generation. So I'm saying that the international community, I know this is a very vague term, but in our case, as the European Union should really pay attention on the fact that our institutions really don't have authentic will and readiness to respond to prosecution.
You can imagine how much better, for all the deficiencies of the domestic system, you can imagine how much better they are having served relentlessly publicly, causing them to do better. Serbia is very fortunate to have such a talented advocate. I'm going to turn to Ina Zoon next. And, I'm mindful of the time. I hope we can at least go to you for the lunch start. Ina, please.
Yeah, it's obviously too early to assess the impact of the group, but now with 1 month before presenting the final report, we can see some positive aspects and some outcomes. And we can see some very effective aspects of this intervention that then is special in that way. First, it was the unprecedented speed of organizing this intervention. As I was telling you, political agreement 1 month after the event and 3 months after already the signing of the contract between the Iranian and the Iranian. The other one was the relatively short time elapsed between the facts and the beginning of the investigation of the technical assistance, which is a huge advantage compared to investigating all crimes. And the participation of the victims and the organizations close to the victims, it was from the beginning very important. And there is an organization in the mountains of Sierra Madre in Guerrero, that is for many years giving support to Argentina Rural School, which was important to make the link into another organization at the local level that ensured the link between the families and the interrelated conditions. So this is very important. As the positive outcomes until now, first, the creation of the group and that intervention, in the specific case of Argentina brings a huge moral for the families of the students and for the human rights movement that has a very high symbolic value. That's the first one. The second one, it was one of the accomplishments of the group until now with the first report, with the midterm report. It was that exposed the lack of consistency of the historical truth of the prosecution of this. So first, about the attack on the students, the experts showed that in fact it was a mega attack, not one attack against one group of students in country to protest, but a series of 9 different attacks in different places of the city of Cuba. Then the motivation, the report of the expert questioned the motivation of the attack and indicated another possible line of investigation where there was one of the buses where the students were in possibly was full with drugs, and the municipal traffic police attacked the students in order to recuperate that bus. And the drugs, the buses were used to send drugs from Guerrero, where poppy seeds are cultivated, to the United States. So without knowing, the students were in one of these buses with drugs. So that was a line of investigation. It is not considered. And the motivation, the core of this investigation, why the police would attack in such a vicious way a group of students. It's totally changed with the intervention of the group. Another point, very important point, was the involvement of the army and the federal and state police. The official version said that only the municipal police were involved in the attack, while the expert group said that at least the state police and the military in the region, they have knowledge and from the beginning, movement of the students and the attack against the students. So even the soldiers participated in bringing some of the injured students at the first moment of the attack to the hospital. So the involvement and the knowledge of the federal authorities, it was clear from the preliminary report, and it was raising questions about the nature of this conflict. Another very important contribution was to call into question the investigative capacity of the institution of the state. On the methodology, as I was telling you, not all the investigation lines were considered by the prosecutor. The second, all the evidence was lost. Very important videos of the moment of the attack, they were lost by the local prosecutors. And out of the 131 people detained in this case by the federal prosecutor, there are indications that 40 were tortured to confess and to declare things that were helpful with the construction of the historical From this perspective, you know, the report and the intervention of the group of experts contributed to the question, the more general question, is Mexico really on the right accountability track? Is Mexico having the internal, the domestic capacity to investigate? Supposing that that would be political way to investigate, but are the institutions really able to manage that the amount and the complexity of the cases that right now are on their desk, and they involve not only organized crime, but also collusion with municipal police, and eventually collusion at a higher level of political and institutional. Another accomplishment until now is very young. Only 8 months. It was a strong impulse for the civil society to organize. It's the first time I'm already 11 years in, and it's the first time I see various Mexican groups sitting together and strategizing together with the victims of experiences and of torture and extrajudicial killing on anti-impunity plans. It's the first time when there are groups of human rights organizations, but also there are groups of people working on corruption and transparency and accountability. There are groups of academics struggling to put data together to look at the patterns of both human rights abuses, patterns of modus operandi of organized crime, and patterns of state responses to this crime, which it didn't happen before. So, in a more general development, the work of the experts feed into the debate of the nature of the crimes committed in Mexico. Are they crimes committed by the organized crime only, or there is an involvement of the state? Are they isolated or inevitable human rights violation in the context of the war against drugs as the government states, or widespread? And there is a incipient consensus that the gravity of the situation in Mexico exceeds the international human rights framework. The civil society is increasingly turning its attention to the international community as a necessary response. Now, there is a huge gap between what the government claims and where the civil society is in this moment with the debate. The government claims that there is no human rights crisis in Mexico. That these are isolated incidents, and when Juan Mendes dared to declare that in Mexico torture is generalized, is widespread, the government responded that Juan Mendes was unprofessional and had no base to claim that was the right.
Thank you so much for that. And again, basic question we have as the clock is running down. If you could reflect on the most effective strategies or interventions in the national community has provided, as well as reflect on things that might have been done differently. And since we don't have a lot of time for additional questions, to the extent you have and work into your response, what some of the most delicate moments were, because I know there have been quite a few in the negotiations of how to balance the pressures you mentioned earlier of achieving the anti-discrimination laws
una pregunta. Yo creo que bueno, sería en este punto tocar un poco la sobre el tema de la publicidad de los procesos. En Colombia, la sensación generalizada de las sociedades, la ineficiencia del sistema, la imposibilidad de actuar del sistema, las amenazas o las oportunidades en las que se ha ahorrado el sistema en Colombia, y esta nueva oportunidad de traer para la paz, es una gran oportunidad para mostrar que se avanza, que sí se dan las cosas como en términos judiciales, y además estos procesos son públicos y me parece importante, pero también me parece muy importante dar claridad sobre el derecho que se va a aplicar en ese contexto, y esto porque digamos, cuando Colombia intenta adaptar los estándares internacionales, los normas del derecho internacional, todo esto. Somos un país de abogados, somos un país que tiene un número considerable de facultades de derecho, y la entrada en vigencia de cualquier tratado internacional es más o menos un puesto para las discusiones nacionales. Entonces, cuando tratamos de traer todas estas figuras a la legislación colombiana y aplicarlas, además no solamente para adecuarlas a la legislación, sino para hacerlas aplicables, vemos unos conflictos enormes que devienen finalmente en una crisis de confianza, porque no se consiguen las reglas del juego, ¿sí? Ni para las víctimas ni para las personas que van a ser juzgadas. Yo plantearía en ese sentido una experiencia vamos porque con esa experiencia nos dimos cuenta que este país de abogados, posturas de justicia tan amplias, nos damos cuenta que el factor de capacidad no necesariamente es el problema que tenemos. El problema que tenemos probablemente es el tema de la confianza en el sistema. Y en ese sentido, lo que planteaba con esta condición de la presencia de los instituciones internacionales, al final es un factor generador de confianza, probablemente. Tendría que decir en este momento que todavía no se conoce cómo van a ser nombrados estos jueces y cuál va a ser su rol. Eso todavía no es claro. Tenemos estado un acuerdo político entre las partes, no tenemos normas claras todavía que desarrollen esos acuerdos, pero sí diría que por ahora lo claro es que se quiso lograr vuelvo al sistema de la forma en que se aplican los estándares internacionales, y creo que esa es la discusión sobre cómo vamos a desarrollar este esfuerzo. En el caso de justicia y paz, vimos cómo los jueces comprendieron y los fiscales comprendieron al final el esquema de cómo tenían que abordar las investigaciones. Claro, hay una gran parte de los fiscales que todavía están tratando de romper con la lógica de caso a caso, de hecho al hecho, una formación jurídica que hemos recibido durante años, y ahora tenemos que conectarnos a unas metodologías, a unas formas de abordar las investigaciones de crímenes internacionales. En ese sentido, creo que es un gran aporte que han hecho los internacionales que observan el proceso de Colombia. Inclusive, yo diría que en los informes de la oficina de la Fiscalía de la CNI plantean que Colombia en términos de confidencialidad es un caso relativamente exitoso, en la medida en que se han abordado estas discusiones de forma mucho más clara, en términos de cómo debemos abordar las investigaciones de crímenes de competencia sin embargo, hay muchas falencias sobre la forma en que traemos esos estándares, ¿no? Voy a mencionar rápidamente la situación que vivió la Corte Suprema de Justicia de Colombia por los casos relacionados con la parapolítica, que eran el juzgamiento de aforados constitucionales de parapolítica del más alto nivel de Colombia, que estaban especialmente involucrados con, o habían, digamos, tenían algún tipo de vínculo con las considera el delito de concierto para el como crimen de lesa humanidad. Esto para ampliar las restricciones, para acabar con las restricciones, para poder llegar al fundamento de objetos que efectivamente sí tienen ciertos vínculos con el particularismo. Sin embargo, fíjense la dificultad que nos pasó en esta situación y darle un tratamiento de crimen de lesa humanidad a un delito como concierto para el yo ahí pensaría que pues, digamos, un poco más amplio, creo que los operadores de alguna manera consideran que aplicar el derecho internacional es un factor de legitimidad de decisiones. Y probablemente, digamos, el planteamiento que yo haría es un adecuado modelo de revisión que puede llevarse a cabo en el marco del derecho nacional y en todo caso también hacer las legislaciones internacionales. La forma adecuada de aplicar el derecho podría terminar en un factor siempre de las decisiones y no planteamos en el debate de si efectivamente las decisiones son legítimas, si hemos considerado el debido proceso, las relacionadas con el poder natural, bueno, diría también que sería clave
Just approaching noon. Sorry. This is approaching noon, so I apologize for if you could wrap up with the most important points you want to make. My apologies on time.
Vale, básicamente lo que diría es que los países estamos orientados a aplicar el derecho internacional, los estándares internacionales tienen que estar orientados a fortalecer los países internos y que de alguna manera nuestras investigaciones de los crímenes frente a la conciencia de la humanidad sean esas investigaciones sean orientadas a que los sistemas nacionales desarrollen las capacidades para investigar ese tipo de crímenes. Ahí es en donde encuentro una gran posibilidad, una gran oportunidad para el acompañamiento de la cooperación internacional en la medida no necesariamente en cómo se calculan los delitos, sino la forma en que se abordan las investigaciones, cómo probar las necesidades de penalidad a partir de la experiencia comparada.
Thank you so much. I'm indebted to each of our panelists for sharing their incredibly rich set of insights with our civil time to their experiences. Thank you for educating us all.